each of which is a first-degree misdemeanor. And the court is on the record in the City of Conneaut versus Darius Anderson, case number 22 CRB 331. This case is set today for a first pretrial conference. The defendant pled not guilty on August 12, 2022 to 2 counts of domestic violence, each of which is a first-degree misdemeanor, and 1 count of aggravated menacing. Court set bond, and as I said, this is the first pretrial conference today. The defendant is present. He's accompanied by his attorney, Tina Scabona. Also present is Law Director John Lewis. The court also received a letter from the alleged victim, in this case, Shannon Anderson. It was filed on August 17th, 2022, requesting that the no contact condition of the defendant's bond be lifted. The court scheduled that case, or that request, for a hearing today, as the court does not consider those letters only if the person is present, physically present in the courtroom, making that request. The court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. I would point out that the alleged victim, there are 2 alleged victims here. Both were served with subpoenas requiring their attendance here today. They were personally served on August 16th, and neither of them are here. For that reason, Your Honor, the offer that's been extended would be plea discharge and argue sentence. I can't really do much else until I speak to the victims, and I've been unable to contact them thus far. Thank you.
Thank you. Ms. Cabona? So if I may, you're asking for a second pretrial?
Yes, Your Honor.
Okay. Ms. Cabona.
Yes, the law director is asking for a second pretrial. At this time, in an attempt to resolve the case, we would be in agreement with the second pretrial. We would ask the court if the court could consider, I know the court stated the letter that was presented, and that the court does not typically consider those. We would ask the court to consider lifting the no contact order. My client does have another child who lives at that home and has had no contact with any of his children nor his wife since the no contact order was put into place. And with school starting, there's a lot of things that need to happen, a lot of gears and things that need to be put into place that cannot be put into place with the no contact order here. And while I can appreciate the court's standard is regarding those letters, we would ask that the court consider dissolving the no contact order in this particular case. My client has moved out. He's out in Cleveland now, and that's where he is residing. And so he is not here, nor is he staying with those individuals. He has his own place out in the Cleveland area, which also adds a little bit to, he can't just drop everything to, go over to the school and answer any questions that might need to happen. So communication is a big issue here. Also, he was unable to get all of his belongings, and he still has belongings in the home. The majority of his clothing items are still at the home, and he would like to be able to go ahead and get those items and at least communicate to try to get those items returned to him. This would not be anything for attempting to harass or anything along those lines. It's just simply to facilitate him being able to talk to his children and then facilitate him being able to get those items.
Well, with respect to obtaining his personal belongings, I did on August 12th, as a condition of his bond, allow him to retrieve his personal belongings at the residence, provided he had a police escort. So that's not happened, Mr. Anderson?
No, as soon as I got out, I just went to where I was going to be at, to get another place to stay. I needed to find a place to stay, because I could no longer go home. I have no family out here. I have no close friends to where I could, stay out here in the area. So at the time I was unemployed, so I got employment in Cleveland, so I'm staying out there. So I never really had the chance to go get, and I just didn't feel comfortable going to get it. So I kind of just stayed all the way away because you were like, no contact. So I kind of just got away and stayed away, basically.
You do remember me telling you that you could go with a police escort?
Yes,
Okay.
yes. No, I know that. But
No,
I'm getting stories that my stuff is
that's all right.
either at a storage unit or it's not, you know what I mean? Like, yeah.
So, I guess my point is you haven't exercised that right yet.
No.
Well, he still has that, he still can do that while this case is pending. Look, I really don't make exceptions on this. I think this is a pretty solid rule that I have in place, and I know a lot of judges do the same thing. Unless this alleged victim is right before me making that request, and she was served with subpoena. She's not here today. She was given a notice of the hearing for today upon her request. We have a certificate of mailing shows that it was mailed on August, I believe it was August 19th. So she should have received that regular mail by today. She knows to be here. She's not here. If she really wants to be here, she can come at any time as long as she's physically here, and I'm here, as long as she's physically here and asks that that condition be lifted. But until she's here to make that request, I'm not going to lift that condition. I will go ahead and set this case for a second pretrial conference in the next 2 to 3 weeks. Mr. Anderson, what is your new address? Is that Mr. Hey, David, how you doing? Good. How are you?
I'm wonderful.
I didn't recognize you.
Nice to see you. 338 Westport Place, Avon Lane.
West what?
Westport.
One word?
Yeah, Westport is one word, yes.
Place. What's the you said what city?
Avon Lane.
Avon Lane. What's the zip? That's okay. That's okay. Well, we can find that, so. Is that just temporary, or is that?
Yeah, so I'm staying with the CEO of Central Pitch where I'm working at. He's letting me stay with him until I can get an apartment.
Okay.
So,
Well, I would encourage you to try to, if the police, of course, this is all dependent upon their availability. If the police are available, I would encourage you to exercise that right to, obtain your personal belongings. We'll schedule this for a second pretrial conference in the near future.
Your Honor, it
Yes.
looks like the zip code would be 44012.
Thank you. Okay, anything further, Mr. Lewis? Ms. Cavona, anything further?
Not at this time.
Okay, Mr. Anderson, you'll go to the clerk's window, and they're going to give you a date and time for your next hearing. So you will know before you leave the building today when your next hearing is.
all right.
Do you have any questions?
No, sir.
Okay. You have a good day. Thank you. Good seeing you.
Good to see you. So, do one question. So if she